Employee and labor relations. The pros and cons of arbitration. The pros of arbitration. Promoted to resolve disputes efficiently, arbitration proponents commonly point to several benefits offered over litigation, court hearings, and trials. It avoids hostility, because the parties in arbitration are usually encouraged to participate fully and sometimes even to help structure the resolution. They are then more likely to work together peaceably rather than escalate their angst and hostility towards one another, which is often the case with litigation. Usually cheaper than litigation, arbitration is becoming more costly as more entrenched and more experienced lawyers take up the cause. It is not unusual, for example, for a well-known arbitrator to charge $3,000 to $4,000 per day. Also, most parties in arbitrations will hire lawyers to help them through the process, adding to their costs. Faster than litigation. According to a recent study by the Federal Mediation and Conciliation Services, the average time from filing to the decision was about 475 days in an arbitrated case. In contrast, a similar case took 18 months to 3 years to wind its way through the courts. Flexible. Unlike trials placed on overcrowded court calendars, arbitration hearings are often scheduled around the needs and availabilities of those involved, including weekends and evenings. Simplified rules of evidence and procedure. The complex rules of evidence and procedure do not apply in arbitration proceedings, making them less stilted and more easily adapted to the needs of those involved. Essentially, arbitration dispenses with the process called discovery that consists of taking and answering interrogatories, depositions, and requests to produce documents. Discovery is often derided as a delaying and game-playing tactic of litigation. In arbitrations, most matters, such as witnesses to be called and documents that must be produced, are handled with a simple phone call. Private. Arbitration proceedings are commonly held in private. Also, parties sometimes agree to keep the proceedings in terms of the final resolution confidential. Both of these safeguards can be a benefit if the dispute's subject matter might cause some embarrassment or reveal private information, such as company's client lists. The cons of arbitration. Being aware of the possible drawbacks of arbitration will help you make an informed decision about whether to enter into or remain in a consumer transaction that mandates it, or whether to choose it as a resolution technique if a dispute arises. Limited recourse. A final decision is hard to shake. If the arbitrator's award is unfair or illogical, a consumer may be stuck with it and forever barred from airing the underlying claim in court. Uneven playing field. Some are concerned that the take-it-or-leave-it nature of many arbitration clauses work in the favor of large employers or manufacturers when challenged by an employee or consumer with less money and/or power. Questionable objectivity. Another concern is that the process of choosing an arbitrator is not an objective one, mainly when an agency picks the decision maker from a pool list, where those who become favorites may get assigned cases more often. Adding possible complications. Many national arbitration groups actively market their services to companies that issue credit cards or sell goods to consumers, casting additional questions on the alleged neutral's objectivity. An arbitrator chosen by a party within an industry may be less objective, more likely to be biased in favor of the appointing group. Lack of transparency. Arbitration hearings are generally held in private, not in open courtrooms, and decisions are usually not publicly accessible. It's considered a benefit by some. However, others lament that this lack of transparency makes the process more likely to be tainted or biased. Especially troublesome because the courts infrequently review arbitration decisions once made. Rising costs. While most still claim that arbitration is less costly than litigation, prices are increasing. According to a recent survey by the Public Citizen, a consumer watchdog group, the cost of initiating an arbitration is significantly higher than the cost of filing a lawsuit. Consider that it could cost $6,650 to $11,625 to arbitrate a consumer claim worth $80,000 versus $221 to file that action in a particular county court. Add the arbitrator's fees, multiply by 3 if a panel is involved, in addition to administrative costs, and the process might be less of a bargain. Know the terms of your agreements. Read or reread all contracts you've entered with a retailer, credit card company, or healthcare provider that may contain arbitration provisions. If the writing obligates you to binding arbitration and that is not your wish, shop around for another provider. Speak your mind. If you find an arbitration clause objectionable, be sure to make your feelings known to company management. It is sometimes possible to negotiate the provisions away if the company wants your business badly enough. For the PHR, Functional Area 5, Employee and Labor Relations, it makes up 39% of the exam content. You must be able to manage, monitor, and/or promote legally compliant programs and policies that impact the employee experience throughout the employee's life cycle. For the SPHR, Functional Area 5, Employee Relations and Engagement, it makes up 20% of the exam content. You must be able to develop and/or monitor strategies impacting employee satisfaction and performance, including diversity and inclusion, safety, security, and labor strategies. You decided, so now it's time to work hard. And good luck to you. Join the 365 HR Certified Study Group on Facebook today. It's free. This slide was created with information sourced from nolo.com, as well as information from the PHR SPHR Study Guide and the World Wide Web.